So usually when we think about international borders, we picture them as these very rigid, absolute lines.
Right, like a literal wall or a checkpoint.
Exactly. It's almost like a geographical toggle switch. You cross a line on a map, you hand over your passport, and instantly you're operating under a completely new jurisdiction.
The rules just flip.
Yeah, the rules change, the tax codes change, the speed limits change. It's a binary reality, and it's built entirely on this idea of territorial sovereignty.
And, well, we find an immense amount of comfort in that kind of clear-cut categorization. I mean, the law generally prefers geography to dictate authority because, simply put, land doesn't move.
Right.
You're physically standing in country A, so therefore country A's laws apply to your actions. It's clean.
But the problem, and this is what we're getting into today, the problem is that human beings are not static entities. And families, specifically, are deeply, profoundly messy.
Oh, excellent.
When you take a marriage or a parent-child relationship or like a bitter custody dispute, and you try to drag that across that rigid geographical line, the toggle switch just breaks.
A chatter.
The legal landscape becomes completely murky. We're looking at a space where territorial rules fundamentally clash with human realities.
And that tension forces the law to figure out how to stretch, adapt, or sometimes just completely discard its own jurisdictional rules.
Which is wild.
It is. And this is the very heart of private international law, or, the concept of laws, as it's sometimes called.
Right.
And for you, the dedicated learner studying this subject, particularly if you're tackling the concepts outlined in Unit 4 of the Osmania University LLB Honors Semester the 4th syllabus, this tension between the sovereign border and the migrating family, well, it's the central paradox you have to resolve.
Okay, let's unpack this. We are dedicating this deep dive to decoding that exact paradox.
It's a big one.
It is. So we're tackling the foundation of legal status through legitimacy and legitimation. Then we'll explore how courts handle the artificial creation of families across borders through adoption.
Right, which is incredibly complex.
Super complex. And finally, we'll analyze the incredibly hostile battlegrounds of international guardianship and custody.
And throughout all of this, we'll be placing English law and Indian law side by side.
Yeah, to see how two different legal systems engineer solutions to the exact same human crises.
So we really have to start with the concept of status, because status is the bedrock upon which all other family law rights are built.
Okay, lay it out for us.
Well, in private international law, a person's civil status dictates their legal capacity. I mean, their ability to marry, to inherit property, to be recognized as a legitimate part of a family structure. It all flows from status.
So let's focus on legitimacy and legitimation, because I know the distinction between those two terms is critical for the exams.
It's a foundational distinction.
Right. So legitimacy is the status acquired at the very moment of birth. Like, a child born to parents who are legally married at the time of the birth is legitimate by operational law from day one.
Exactly. Day one status.
But legitimation, on the other hand, is a subsequent legal upgrade.
That's a great way to put it. An upgrade.
Yeah, so a child is born out of wedlock, but a later event, which is, almost always the subsequent marriage of the parents, elevates that child's status to legitimate.
And the central question for private international law here is determining which country's law actually has the authority to grant that status.
Because they're moving across borders.
Exactly. If a family is moving across borders, who holds the keys to declaring a child legitimate?
Who gets to push the upgrade button?
Right. And according to jurists like Cheshire, civil status is governed universally by one overarching principle, and that principle is domicile.
Okay, I really want to push on how domicile actually functions here, because it's often treated in everyday conversation as just a fancy word for your home or your address.
It is, yeah. But legally, it's so much more.
Right. Legally, it operates much more like an invisible operating system running in the background of your life.
I love that analogy.
Like, if my domicile is French, I'm running French software regarding my personal status, my majority age, my capacity to marry.
Yes.
If I travel to England, I'm operating on a foreign network, obviously. But my internal system permissions, they're still dictated by French law.
That is an incredibly precise way to visualize it. And you have to understand, your domicile of origin, which is given to you by operation of law at birth, is very sticky.
Sticky how? Like hard to change.
Extremely hard to change. It's typically based on your father's domicile if you are legitimate or your mother's if you're illegitimate, and it requires a concerted legal effort to override it by acquiring a domicile of choice.
Okay, so how do you get a domicile of choice?
It demands two things: physical residence in a new country and the absolute intention to remain there permanently. The animus menendi.
Animus menendi, intention to stay.
Right. Until you successfully install that new operating system, so to speak, the old one governs your status wherever you go.
Which actually brings us to a massive hypocrisy in English legal history that was highlighted in the source material we're looking at. Oh, the 1926 issue?
Yes. For centuries, English domestic law flatly refused to recognize legitimation by subsequent marriage.
They were incredibly strict about it.
Like, if you were born out of wedlock in England, you were illegitimate, full stop. Even if your parents married, like, an hour after your birth, the domestic law refused to upgrade your status.
They didn't change this internally until the Legitimacy Act of 1926.
Right. So why were they so stubborn about it?
Well, that internal stubbornness was rooted deeply in English property law, specifically the protection of noble bloodlines.
Of course. Follow the money, or the castles, I guess.
Exactly. They were terrified of bloodlines being diluted by children born outside of a sanctioned marriage inheriting large estates. Yet, and this is the crazy part, while Parliament was fiercely guarding the bloodlines at home, English common law courts were simultaneously recognizing foreign children as legitimated.
It's a fascinating double standard.
It is. So if a child was domiciled in a country like France, where the domestic law did allow legitimation by subsequent marriage, and that child's parents later married, the English courts recognized that child as fully legitimate for the purposes of English proceedings. They were honoring a foreign status that they explicitly banned within their own borders. How on earth does a court justify that level of cognitive dissonance?
Well, it wasn't cognitive dissonance to the judges of the time. To them, it was a pragmatic deference to international comity.
Comity meaning like mutual respect between nations.
Exactly. The English courts understood that if status is truly a universal concept governed by domicile, then they couldn't just cherry pick which parts of the foreign operating system they liked.
Okay, so it's all or nothing.
Right. Grayson's analysis on this in the text is really sharp. He points out that to refuse recognition of a validly acquired foreign status would create what he calls limping relationships.
Limping relationships, I like that term. Meaning what, exactly?
Meaning a person who is entirely legitimate in Paris, but the moment they cross the channel to London, they're suddenly a bastard under the law.
Wow. Yeah, that would be a logistical nightmare.
It would. So the courts prioritized international harmony and the universality of status over enforcing their own, frankly, antiquated domestic morality on foreign citizens.
So basically, they were accepting a VIP pass from another club, even though their own club didn't issue those passes yet.
That's exactly what they were doing.
That's surprisingly cosmopolitan for a legal system that's usually known for its rigidity, you know? They recognize that holding a monopoly on morality just stops working the second you hit the border. If French law updated the child's software to legitimate, the English courts just accepted the update.
It also perfectly illustrates a broader theme you'll see in your studies. Private international law often acts as this progressive wedge against conservative domestic laws.
Because the international reality just forces the domestic system to evolve eventually?
Precisely. They couldn't maintain the double standard forever, which led to the 1926 Act.
Okay, so that deals with the biological reality of status. But if recognizing natural status across borders is a headache, legally manufacturing a entirely new parent-child relationship across borders via adoption, I mean, that has to be an absolute minefield.
Right, it is the ultimate legal transplant.
Right, because you are asking one sovereign nation to permanently extinguish the biological parents' rights and transfer them to citizens of another nation entirely.
And because the stakes are so permanent, the jurisdictional rules surrounding adoption are incredibly defensive.
Defense how?
Well, let's look at English domestic law, which was governed historically by the Adoption of Children Act 1926 and later consolidated in the Adoption Act 1976. An English court will only grant an adoption order under very, very strict conditions.
What are the conditions?
The prospective adoptive parent must be domiciled in England or Scotland, and both the applicant and the infant must be physically resident in England.
Wait, so domicile plus residence?
Yes, a double requirement.
That is an immense barrier to entry.
Yeah.
I mean, you can't just engage in forum shopping then.
Exactly, that's the whole point.
You can't just, fly into London on a tourist visa, finalize a quick adoption, and fly out. The court won't even hear you.
They won't, because the English system views adoption not merely as a private contract between parties, but as the fundamental integration of a child into the social fabric of the state.
They're taking responsibility for this new citizen.
Right. So if the adoptive parents aren't deeply tethered to the English legal system through domicile, the state feels it has no long-term authority to ensure the welfare of that child. They demand that the new family unit be firmly anchored in their jurisdiction before they sign off.
Makes total sense.
Yeah.
But again, let's flip the scenario, because this is private international law.
Yeah.
What happens when the situation is reversed? Like a family walks into an English court holding an adoption decree that was granted in, say, South Africa or India.
This is where we get to the landmark case, Valentine settlement.
Oh, right. Valentine settlement. This is a huge one for the syllabus.
It is. In this case, Lord Denning, who is a giant in English law, laid down the common law rule for recognizing foreign adoptions. And he essentially applied a reciprocal trade agreement framework.
Reciprocal, like I'll scratch your back if you scratch mine.
Essentially, yes.
Yeah.
He applied the principle of mutuality, and this was famously derived from an older case, Travers v. Hawley.
Okay, so what did Lord Denning actually rule?
He ruled that an English court will only recognize a foreign adoption if the foreign court assumed jurisdiction under similar circumstances that an English court would require.
Ah, a mirror test.
Exactly, a mirror test. Since an English court demands the adoptive parents be domiciled in England to grant an adoption, they will only respect a foreign order if the adoptive parents were domiciled in that foreign country at the time of the adoption.
So, we won't respect your authority unless you play by our strict jurisdictional rules.
That is exactly the logic. But Valentine settlement goes even further than just the mirror test. The Court of Appeal established a massive public policy exception.
Okay, what does that mean in practice?
It means that even if the South African court, or wherever the adoption took place, had perfect jurisdiction, the English court still reserved the right to strike down the adoption if it offended English public policy.
Give me an example. Why would they strike it down if the jurisdiction was perfect?
Because the court was highly aware of the potential for abuse. You see, in many jurisdictions, particularly historically, adoption wasn't always about child welfare. It was frequently used by adults as a tool to secure financial advantages, to dodge tax liabilities, or, very commonly, to artificially manipulate the line of succession for a massive estate.
Oh, wow. So adopting an adult or a specific relative just to ensure they inherit the castle?
Exactly. So if an English court suspected that a foreign adoption was basically a sham transaction designed purely to rewrite a will, rather than a genuine assumption of parental responsibility, they would refuse recognition on public policy grounds.
Okay, which brings us to the most baffling part of Valentine's settlement. And I really want you to clarify this for me, because when I was reviewing the source material, it blew my mind.
The succession issue.
Yes. The court highlighted this severe split between recognizing the child's status and recognizing the effects of that status on inheritance.
It's a very counterintuitive concept.
Let me make sure I'm interpreting this correctly for our listeners.
Yeah.
So an English court could look at a foreign adoption, apply the mirror test, say, okay, everything looks good. They declare the adoption valid under the lex domicili, and they recognize the child as the legal son or daughter for all everyday purposes.
Yes, they do.
But then when the adoptive father dies, that exact same child could be completely excluded from inheriting the estate under English law. How is that possible?
You are interpreting it flawlessly, and I know it sounds crazy. It really highlights the brutal friction between different branches of law.
It's totally schizophrenic.
It is, because status is governed by the lex domicili, the law of the domicile. But the inheritance of property, particularly real estate, is governed by the lex successionis, the law of succession.
Okay.
And prior to modern statutory interventions, English succession law was intensely, overwhelmingly prejudiced in favor of biological bloodlines.
It feels like a massive legal bait and switch.
That's a perfect description.
Right, because the law invites you into the family, grants you the family name, imposes all the duties of a child upon you, like taking care of the parent. But the literal moment the estate is divided, the law points at you and says, sorry, you're a legal stranger.
It's a harsh reality, but it was born out of those feudal land systems we talked about earlier. The common law courts were absolutely terrified of disrupting entrenched property rights.
Because other relatives were waiting in the wings for the money.
Exactly. The remaindermen. Distant biological relatives who expected to inherit the estate if the primary line died out. The common law judges felt they couldn't just unilaterally rewrite succession rules and strip those relatives of their expected inheritance just because a foreign domicile granted an adoption.
So how did they finally fix this? Because I assume they didn't leave it like that forever.
They didn't, but it took explicit statutory reform. The Adoption Act 1976 finally harmonized this, officially declaring that a recognized foreign adoption generally has the exact same effect as an English one for succession purposes.
Okay, good. That tension between modern family dynamics and archaic property laws is just fascinating. But let's pivot now, because we really need to look at the Indian perspective on adoption.
Yes, the Osmania syllabus specifically focuses on inter-country adoptions under Indian law.
Right. And the watershed moment here, unlike in England, isn't a piece of legislation passed by Parliament. It's actually a 1984 Supreme Court judgment, Laxmi Pandey v. Union of India.
A monumental case. And the context of Laxmi Pandey is absolutely vital for you to understand.
Set the scene for us.
Right.
What was going on in 1984?
Well, while England had a highly regulated statutory framework for adoption dating all the way back to the 1920s, India in the early 1980s had a gaping void in its law regarding foreign parents adopting Indian children.
A void, like no laws at all.
There was no comprehensive statutory mechanism governing inter-country adoption. It was a free-for-all.
That is terrifying. A legal vacuum involving the transfer of vulnerable children across international borders. You essentially had an unregulated export market.
That is tragically exactly what was happening. And that's why Laxmi Pandey, who was an attorney, initiated this public interest litigation, or PIL.
Based on what? What was he seeing?
He filed it based on widespread reports of severe malpractices. Unscrupulous agencies and orphanages were essentially trafficking children under the guise of inter-country adoption.
Oh, that's horrific.
It was. Foreign parents, who often had good intentions, were acquiring children with zero vetting. And worse, there was absolutely no mechanism in place to monitor whether those children were actually safe once they left Indian soil. They just disappeared into the system abroad.
So what did the Supreme Court do? Because if there's no law, their hands are kind of tied, right?
Normally, yes. But in this case, the Supreme Court stepped into this void in a massive way. They didn't just interpret existing law, they effectively drafted a comprehensive international administrative code straight from the bench.
Wow. So they just created the law themselves.
It's one of the most aggressive and frankly necessary instances of judicial activism in Indian history. They relied on their constitutional mandate to protect the fundamental rights of children.
Article 21, right.
Yeah.
Right to life and liberty.
Exactly. And relying on that, they laid down exhaustive, binding guidelines that govern the entire process to this day.
What were the main rules they put in place?
Well, first and foremost, they mandated that foreign prospective adoptive parents could no longer engage directly with Indian orphanages. That direct pipeline was cut off.
To stop the financial transactions and bribery.
Exactly. Instead, foreign parents had to be sponsored by government-recognized child welfare agencies in their own home countries.
Okay, so they forced foreign sovereign agencies to basically become guarantors for the parents.
Precisely. If, say, a Swedish couple wanted to adopt an Indian child, the Swedish government's recognized agency had to conduct the home study. They had to evaluate the psychological fitness of the parents, and they had to officially commit to sending post-adoption follow-up reports back to India for years.
That's brilliant. You're outsourcing the vetting to the country where the child is actually going to live.
It was a very smart transnational regulatory framework built entirely on judicial fiat. And the philosophical core of the Laxmi Pandey judgment was establishing a strict hierarchy of placements.
Hierarchy of placements, meaning who gets priority to adopt?
Yes, because the absolute paramount consideration was the welfare of the child. So the court dictated that inter-country adoption is a last resort.
Ah, so domestic first.
Always. Every effort must first be made to find a domestic placement within India to keep the child anchored in their cultural, social, and linguistic roots. It's only when domestic options are completely exhausted that the child can be placed internationally.
They shifted the entire paradigm. It went from finding a child for a family to finding a family for a child.
That is exactly the shift.
Okay, but as complex as finalizing a permanent adoption across borders is, it honestly pales in comparison to the chaos of ongoing temporary rights, which moves us into the realm of guardianship and custody.
Yes, this is where it gets really contentious.
Right, because adoption extinguishes prior rights, but custody manages ongoing rights. When parents are actively warring over a child, and an international border sits right between them, the jurisdictional rules don't just clash, they implode.
Because custody is an ongoing shifting dynamic, courts have to constantly evaluate and reevaluate their authority to intervene in the family's life.
So let's start with English law again. What's the foundational concept granting English courts the power to intervene in a child's life?
Under English law, the foundation is the doctrine of parens patriae.
Meaning the state acting as the ultimate parent of the nation.
Yes. And we see this principle crystallized in a very old 1843 case called Johnstone v. Beattie.
Okay. What's the rule from Johnstone v. Beattie?
The rule established there is astonishingly broad. It states that the Lord Chancellor, representing the sovereign, has the right to intervene and protect any infant physically present within the jurisdiction.
Wait, any infant?
Any infant. It does not matter if the child is an alien. It doesn't matter if their domicile is in another hemisphere. Mere physical presence is enough to trigger the court's protective authority.
Because the state owes a duty of protection to anyone standing on its soil, especially minors who lack legal capacity.
Exactly.
But I've got to say, I see a massive vulnerability in that doctrine.
Oh, there definitely is one.
If mere physical presence is enough to grant a court jurisdiction to make custody orders, doesn't that inherently incentivize international kidnapping?
It absolutely does.
Like, if I lose a custody battle in France, what stops me from just smuggling the child across the channel into England, claiming the child is now physically present there, and demanding the English court use its parens patriae power to reopen the whole case from scratch?
You've identified the exact hazard that plagues private international law in family matters. Broad protective jurisdiction can so easily be weaponized by a bad faith actor.
It's a huge loophole.
It is. And the English courts eventually recognized this risk, which is why, over time, they had to develop mechanisms. And later, they signed international treaties like the Hague Convention on Civil Aspects of International Child Abduction to differentiate between a child who is genuinely residing in the jurisdiction and a child who has been illicitly transported there merely to manufacture jurisdiction.
Okay, so that's the English side. Does Indian law operate on a similar trigger? Like, does physical presence equal judicial power in India?
Well, Indian courts do follow the broad, equitable principles of English law regarding the assumption of jurisdiction, but it's much more heavily codified, specifically under the Guardian and Wards Act, 1890.
Right, the Guardian and Wards Act. What does that say about jurisdiction?
Under Section 9 of that act, a guardian court generally assumes jurisdiction based on the child being ordinarily resident within its local limits.
Ordinarily resident. So that's a slightly higher bar than mere physical transit, right? Like, you can't just be passing through the airport.
Exactly. It requires a degree of settled presence. But once jurisdiction is established under the Act, the Indian court applies the lex for its own local procedural laws, along with the personal laws applicable to the parties, whether that's Hindu law, Muslim law, Christian law, etc.
Okay. But regardless of whether an Indian judge is applying the Guardian and Wards Act or an English judge is invoking parens patriae, there has to be one supreme directive that supersedes all these jurisdictional technicalities.
There is. If we connect this to the bigger picture, the overarching universal principle that trumps almost all rigid jurisdictional rules in both systems is the welfare of the child.
The welfare of the child. It's the North Star of family jurisprudence.
It truly is.
It kind of reminds me of a hospital emergency room.
How so?
Well, if a sick child walks into an ER, the doctor doesn't stop and check their passport or their parents' visa status before giving first aid, right?
No, they treat the immediate harm.
Exactly. The court sees itself as the ultimate guardian in the same way. If a child is in their territory and in danger, they have an absolute duty to protect them. Jurisdictional rules be damned.
I think that's a brilliant analogy, and it is this exact protective instinct, this ER mentality, that creates the most spectacular legal collisions when foreign custody orders are brought before a domestic court.
So let's examine one of those collisions, because this is where the theory hits reality. The Kerala High Court case of Margaret v. Dr. Chaco from 1970. This case is practically a legal thriller.
It really is. The facts perfectly illustrate the clash between rigid legal status and messy human reality.
Break it down for us.
Okay, so Dr. Chaco is an Indian citizen. He has an Indian domicile of origin. He moves to Germany for his medical studies.
Pretty standard so far.
Right. While there, he marries Margaret, who is a German citizen domiciled in Germany. They establish their life there. They have 2 children together in Germany. But eventually, the marriage collapses. The German court intervenes, and after a hearing, they grant primary custody of the children to the mother, Margaret, and they provide visitation rights to Dr. Chaco.
So a completely standard, legally binding foreign custody order.
Exactly. But Dr. Chaco defies the order. He takes the children, smuggles them out of Germany, and flees back to his native Kerala in India.
So he essentially kidnaps them.
Legally, yes. Margaret, to her credit, pursues him across the globe. She travels to India and files a habeas corpus petition in the Kerala High Court, demanding that the Indian court enforce the German custody order and return her children.
Okay, so Dr. Chaco is in court. What's his defense? Because he clearly violated an order.
His defense is a masterclass in exploiting legal technicalities. He didn't even try to argue that Margaret was an unfit mother or that the children were in danger with her.
Wow, really? So what did he argue?
He argued that the German court never had the right to make the order in the first place. He claimed that because he never legally abandoned his Indian domicile of origin, he always intended to return home eventually, his children automatically inherited his Indian domicile at birth.
Because of that sticky domicile of origin rule we talked about.
Exactly. Therefore, he argued, because the children had an Indian domicile, only an Indian court had the true jurisdiction to decide their custody.
He tried to use his invisible operating system as a jurisdictional shield against the kidnapping charge.
It was a very clever attempt to prioritize a legal fiction over the lived reality of the children.
But the judge didn't buy it.
No. Justice Govindan Nair of the Kerala High Court saw right through it. He actually leaned on English precedents, notably Lord Denning's skepticism about using a dependent's technical domicile as the sole metric for jurisdiction in the modern world.
So what did the judge look at instead?
He looked at the facts on the ground. He looked at where the children actually lived.
Their ordinary residents, like in the Guardian and Wards Act.
Precisely. The children were born in Germany, they went to school in Germany, their entire social ecosystem, their friends, their routine, it was all in Germany.
So Germany was their home, regardless of this abstract legal tether to Kerala.
Right. Justice Govindan Nair ruled that ordinary residence is a far more robust, realistic basis for jurisdiction in custody matters than a highly technical, inherited domicile. So he validated the German court's authority.
And what about the foreign order itself? Did he just rubber stamp it?
It's not rubber stamp, but he respected it. He noted that while Indian courts are not bound to blindly enforce foreign judgments, the Comity of Nations requires courts to respect orders passed by competent foreign jurisdictions after a fair trial, especially when it aligns with the child's welfare.
So he enforced the German order and restored the children to their mother.
He did.
It's a massive triumph of common sense over legal pedantry. But honestly, Margaret v. Dr. Chaco is relatively straightforward because the father's jurisdictional argument was so flimsy and he was clearly in the wrong.
Well,
The modern reality in Indian private international law is far more complex than that case. The courts are currently caught in this agonizing tug of war between two opposing duties.
the duty to respect the comity of courts versus the duty to protect the welfare of the child.
Right. It's the ultimate dilemma. If a child is abducted to India, the Comity of Courts dictates that the Indian judge should immediately pack the child on a plane and send them back to the foreign jurisdiction. Respect the foreign judge, don't interfere with their case.
Yes, the summary return principle.
But the welfare of the child doctrine, that ER mentality, demands that the Indian judge stop the plane, interrogate the parents, evaluate the child's psychological state, and make a totally independent decision. Never blindly send a child into potential harm.
It's an incredibly difficult balance.
So how does the Supreme Court of India reconcile those two extremes today?
The definitive framework for resolving this exact tension was laid down by the Supreme Court in a massive landmark case called Suryavadanan v. State of Tamil Nadu.
Suryavadanan. If you're listening and taking notes, star this case.
Absolutely. In Suryavadanan, the court created an analytical mechanism to help domestic judges decide whether to conduct a summary inquiry or an elaborate inquiry.
Okay, define those two for us. A summary inquiry is what?
A summary inquiry is a rapid, surface-level review of the facts, which almost always results in immediate repatriation of the child to the foreign country. It prioritizes comity and returning the parties to the original forum.
Got it. And an elaborate inquiry.
An elaborate inquiry is a full, exhaustive trial on the merits of the custody dispute conducted locally in India, which prioritizes domestic welfare analysis over foreign comedy.
Okay, so how does a judge choose between the two? Because they can't do both.
The court provided 4 distinct factors that every domestic judge must weigh.
Well, let's go through them. Factor 1.
The first factor is the nature and effect of the foreign court order.
Meaning what?
Meaning, is the domestic Indian court being asked to override a final, exhaustively litigated custody decree from a U.S. court where both parents presented evidence for a year? Or is it merely an ex parte interim order like an emergency injunction passed before the fleeing parent even had a chance to present their side of the story?
Ah, I see. If it's just an interim order, the Indian court might feel much more justified in stepping in and conducting an elaborate inquiry because the foreign court hasn't fully evaluated the facts yet. They haven't heard the whole story.
Exactly. The deference owed to a final judgment is much higher than to a temporary order.
Okay, makes sense. What's the second factor?
The second factor requires the domestic court to look for special reasons for or against repatriation.
Special reasons like what?
Well, the Supreme Court made it clear that an elaborate inquiry should not be ordered as a matter of course. There is a very strong presumption in favor of returning the child to the jurisdiction of their ordinary residence.
So the default is send them back.
Yes. It requires a compelling, documented, special reason to shatter that presumption and assume local jurisdiction. Something extraordinary about the case.
Which feeds directly into the third factor, and this is where I really struggle with the court's logic.
A harm analysis.
Yes. The third factor asks the court to assess whether repatriation will cause physical, moral, or psychological harm to the child. Now, that makes perfect sense. Obviously, don't send a child back to an abusive environment.
Right. Child welfare is paramount.
But it also demands the court assess whether repatriation will cause legal harm to the fleeing parent.
Yes. You are referring to situations where the foreign court has issued arrest warrants against the abducting parent.
Exactly. And this is where I push back. So, if a mother abducts her child from the UK in blatant violation of a court order, the UK will likely issue a non-bailable warrant for child kidnapping.
Almost certainly.
Right. So if she is forced to repatriate by the Indian port, she faces immediate arrest at Heathrow Airport the second she lands.
She does.
The Suryavandanan judgment suggests the Indian court should factor that legal harm into its decision on whether to send the child back. But hold on. Doesn't that create a massive moral hazard?
It looks like it, yes.
It essentially rewards the abductor for creating a high-stakes criminal mess. The more aggressively you violate the foreign law, the more legal harm you face upon return, and therefore, paradoxically, the more likely the Indian court is to say, oh, we can't send you back, you'll go to jail, and let you keep the child in India.
It is a profound paradox, I grant you, but you have to look at it through the lens of the child's immediate reality, not just the parent's culpability.
Okay, explain that. How is protecting a kidnapper helping the child?
Imagine the scenario you just described. If the Indian court orders a summary return and the mother is arrested the literal moment she clears foreign customs, what happens to the child?
They're separated.
Instantly separated. The child is ripped away from their primary caregiver in an airport terminal and likely thrown into a foreign foster care system for months while the mother awaits a criminal trial.
Oh, wow. Yeah, that's incredibly traumatic.
The court isn't trying to reward the kidnapper. It is trying to prevent the child from becoming collateral damage in the criminal justice system.
Okay, when you frame it like that, it makes sense. It's not about the parent's freedom. It's about not traumatizing the kid at border control.
Precisely. The Indian courts are fiercely protective of the child's psychological stability. So in cases where arrest warrants exist, the Supreme Court often attempts a sort of diplomatic compromise.
What kind of compromise?
They might order the child's repatriation, but on the strict condition that the abandoned parent drops the criminal charges in the foreign jurisdiction. Or they demand assurances that the fleeing parent won't be arrested upon arrival, ensuring they can return and litigate the custody dispute fairly without facing jail time.
Well, that's clever. It's an attempt to engineer a safe landing for the family unit.
Exactly. A safe landing. And that brings us to the fourth factor of the Suryavandanan test, which is arguably the most powerful one in practice. Alacrity.
Alacrity. The speed at which the aggrieved parent moves the court.
Right. Time creates its own reality in family law.
That's so true.
If a child is abducted from New York to Mumbai, and the father immediately files for habeas corpus within weeks, the Indian court is highly likely to order a summary return. because the child's roots are still in New York.
Right. They haven't settled in Mumbai yet. But what if the father waits 2 years to file? Or what happens all the time in India? What if the litigation drags on for 3 years in the lower courts before finally reaching the Supreme Court?
Then the child has grown new roots. They are enrolled in an Indian school, they speak a new language or dialect, they are integrated into a new community and extended family.
They're a different person by then.
They are. And at that point, ordering a summary return to New York isn't repatriation anymore, it is a second traumatic uprooting.
Right.
The Supreme Court has repeatedly held that significant delays force the domestic court to conduct an elaborate inquiry because the child's current welfare in India now supersedes the comity owed to the foreign court. The clock is the enemy of the left-behind parent.
Okay, so those are the 4 factors of Surya Vedanan: interim versus final order, special reasons, harm analysis including legal harm, and alacrity.
Yes.
And we see these 4 factors being stress-tested across a rapid succession of Supreme Court precedents. I want to hit a few of these quickly so our listeners can see how this actually plays out in court.
Sure, let's do a rapid fire.
Look at Shilpa Agarwal v. Ivral Mittal. Both parents were British citizens of Indian origin permanently residing in the UK. The mother brings the child to India.
In that case, the Supreme Court directed immediate repatriation back to the UK, essentially applying a summary approach.
Because they utilize the doctrine of intimate contact.
Exactly. The court determined that the UK was the jurisdiction with the most intimate contact with the minor and the parents. It was their natural forum. They refused to let the mother unilaterally shift the jurisdiction to India just by boarding a flight.
Okay, now take V. Radhichandra. The mother removed the child from the USA in blatant violation of a New York family court order. And crucially, it was an order she'd explicitly consented to.
Right, a consent decree. The Supreme Court ordered immediate repatriation there as well. They found no evidence that returning to the USA would cause psychological harm to the child, and they were vehemently opposed to letting a parent benefit from openly flouting a consent decree.
Comedy won out. But contrast that with Ruchi Maju.
Ruchi Maju is a great jurisdictional case.
The mother brings the child, who is an American citizen, to Delhi. The father secures a protective custody warrant in the U.S., but the mother files for custody under the Guardian and Wards Act locally in Delhi.
And here, the Supreme Court had to evaluate jurisdiction strictly based on ordinary residence, which we discussed earlier.
Right. Did Delhi have jurisdiction?
They ruled that because the child was essentially abducted and only temporarily visiting Delhi, they could not be considered ordinarily resident there. The Delhi court lacked the basic statutory jurisdiction to even entertain the custody petition.
They threw it out.
Yeah.
And regarding those arrest warrants we debated earlier, the case of Rathi Bandi is really instructive.
Yes, the Seattle case.
The mother violated a Seattle court order, resulting in U.S. arrest warrants. Red Interpol notices, the whole deal.
And the Supreme Court maintained that the child must be returned to the foreign jurisdiction regardless. The mere existence of an arrest warrant wasn't an absolute veto against repatriation, though, again, the court mandated safeguards to mitigate the fallout for the mother.
Right, they tried to ensure a safe landing. So when you synthesize all these cases, a really clear philosophical shift emerges, doesn't it?
It absolutely does.
Because traditional private international law, like we talked about with the English courts in the 1920s, it was obsessed with abstract concepts like domicile of origin. It was a jurisprudence of labels. You are an Indian domiciliary, therefore X.
Yes, it was very theoretical. But modern courts, especially when dealing with children, are transitioning to a jurisprudence of reality.
I love that phrase, jurisprudence of reality.
They care less and less about the invisible operating system of domicile and much more about intimate contact, ordinary residence, and the daily lived experience of the child.
It's a staggering evolution. I mean, we started this deep dive talking about absolute rigid borders. We saw how English courts historically tied themselves in knots over domicile to protect landed estates.
Right.
We saw the Indian Supreme Court construct an entire inter-country adoption framework out of thin air to protect vulnerable children from trafficking.
A massive undertaking.
And we watched judges navigate the impossible paradox of honoring foreign sovereign orders while simultaneously trying to protect an abducted child standing right in front of them in the courtroom.
It is an imperfect system. It's constantly struggling to balance the rigid demands of territorial sovereignty against the fluid emotional reality of human relationships. It's never going to be completely clean.
Which leaves us with a final massive paradigm shift to consider. because the world is changing so fast.
It is.
As international travel becomes seamless, as remote work untethers us from geography, and as multinational families become the standard rather than the exception, we have to question the very foundation of this legal matrix.
Yes. This raises an important question for the future. Will the traditional concept of a single, exclusive domicile even survive the next 50 years?
That is the existential question for private international law. If a child spends 6 months in London, 3 months in Mumbai, and 3 months in Dubai every single year, attending online schools, holding multiple passports, the concept of a singular ordinary residence begins to fracture entirely.
It completely breaks down. We may be approaching a future where global citizenship requires an entirely new, borderless framework of family law, one based not on where you sleep or what soil you're standing on, but on the network of human connections you maintain.
A legal system that finally realizes the map is not the territory.
Exactly.
That is a heavy concept to digest, especially if you're analyzing these cases for your Osmania University exams. You need to look beyond the rulings and see the friction between the state and the family.
Don't just memorize the rules, understand why the rules are breaking.
Exactly. Thank you for joining us on this exhaustive journey into private international law. Keep pushing back on the precedents, keep interrogating the structures around you, and above all, stay insanely curious.